Title: Can someone without ownership transfer property? Unraveling the Mysteries of Sects, 41, 42 and 43 of the Transfer of Property Act with Your Vinay Shukla. Ever heard of someone selling a house they don't own? Sounds crazy, right? But the Transfer of Property Act, 1882, has some surprising twists. In this video, Legal Eagle Your Vinay Shukla dives deep into sections 41, 42, and 43, exploring the complex scenarios where unauthorized persons, not the full owner, attempt to transfer property. Get ready to uncover who qualifies as an ostensible owner and how they can trick buyers. The legal loopholes that make such transfers valid in specific situations. The crucial difference between Estoppel and Bona Fide purchaser. How to protect yourself from falling victim to unauthorized property transfers. Real-life cases that illustrate the practical application of these sections. This video is a must-watch for home buyers and sellers. Safeguard your biggest investment with clear understanding of property transfer rules. Investors and landlords, avoid legal pitfalls and protect your rental properties. Legal professionals, sharpen your knowledge of these intricate sections of the Act. Anyone curious about property law, get a fascinating glimpse into the legal world of ownership and transfers. Join Your Vinay Shukla on this thought-provoking journey through the Transfer of Property Act. You'll leave with valuable insights and practical knowledge to navigate the world of property with confidence. Subscribe now and hit the bell for more legal wisdom from Your Vinay Shukla.
Section 41 Transfer by ostensible owner where, with the consent, express or implied, of the persons interested in immovable property, a person is the ostensible owner of such property and transfers the same for consideration. The transfer shall not be violable on the ground that the transferor was not authorized to make it, provided that the transferee, after taking reasonable care to ascertain that the transferor had power to make the transfer, has acted in good faith.
Section 41 of the Transfer of Property Act, 1882, deals with situations where someone other than the actual owner of a movable property, land and buildings, transfers it to another person, but with the consent of the real owners. Let's break down the section into its key parts. Conditions for a valid transfer. 1. Ostensible ownership. The person transferring the property, transferor, must appear to be the owner with the consent, express or implied, of the real owners. This means the true owners must have allowed the transferor to act as if they own the property, either explicitly or through their actions or inaction. 2. Consideration. The transfer must be made for something of value in return, such as money, another property, or a service. Free transfers under this section are not valid. 3. Due diligence by transferee. The person receiving the property, transferee, must have acted in good faith and taken reasonable steps to ensure the transferor was authorized to transfer the property. This might involve checking land records, titles, or seeking legal advice. Consequences of a valid transfer. If all conditions are met, the transfer to the third party, transferee, is generally valid and cannot be challenged by the real owners, even if they did not give express consent. This protects good faith purchasers from losing the property unexpectedly. Exceptions and defenses. The true owner might have defenses against the transfer if the ostensible ownership was obtained through fraud, misrepresentation, or undue influence. If the transferee knew or should have known about the lack of authorization, the transfer might be invalid. Specific exceptions to Section 41 might exist depending on the jurisdiction's property laws. Limitations. The concept of ostensible ownership is not absolute. The type of property, the relationships between the parties, and the transferee's actions can all influence the validity of the transfer. Additional points. Section 41 only applies to immovable property, land and buildings. Legal advice is recommended in such situations to understand the specific legal framework and potential risks. I hope this elaboration provides a clearer understanding of Section 41. Please let me know if you have any further questions or want to discuss specific scenarios.
Section 40 to transfer by person having authority to revoke former transfer, where a person transfers any immovable property, reserving power to revoke the transfer, and subsequently transfers the property for consideration to another transferee. Such transfer operates in favor of such transferee, subject to any condition attached to the exercise of the power, as a revocation of the former transfer to the extent of the power.
Here's a breakdown of Section 42 of the Transfer of Property Act, 1882. Key points. Applies to immovable property, land and buildings. Deals with situations where a transferor reserves the right to revoke a previous transfer. Governs the effect of a subsequent transfer to another transferee. Conditions. 1. Initial transfer with power to revoke. A person transfers immovable property but includes a provision in the transfer document that allows them to revoke the transfer later. 2. Subsequent transfer for consideration. The same person then transfers the same property to another person, second transferee, this time for value, money, another property, or service. Effect of subsequent transfer. The subsequent transfer effectively revokes the previous transfer to the extent of the power reserved in the initial transfer. This means the second transferee's rights take precedence over the first transferee's rights, subject to any conditions attached to the power of revocation. Example. A leases a house to B, reserving the power to revoke the lease if B misuses the property. Later, A leases the same house to C, believing B has misused it. C's lease effectively revokes B's lease, but only if the surveyor confirms B's misuse, as per the condition in the initial transfer. Important considerations. Conditions for revocation. The power to revoke must be exercised in accordance with any conditions specified in the initial transfer document. Priority of subsequent transferee. The subsequent transferee's rights generally have priority over the first transferee, but this can be affected by specific conditions or legal challenges. Legal advice. It's essential to seek legal guidance when dealing with such transfers to ensure proper understanding of rights and obligations, as property laws can be complex and vary by jurisdiction. Additional notes. Section 42 primarily applies to leases and similar transfers of possession, rather than outright sales. The concept of reserving a power to revoke is often used in conditional transfers or to protect the transferor's interests in specific circumstances. I hope this elaboration clarifies Section 42. Please feel free to ask if you have any further questions or require more specific information.
Section 43 Transfer by unauthorized person who subsequently acquires interest in property transferred, where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and professes to transfer such property for consideration. Such transfer shall, at the option of the transferee, operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. Nothing in this section shall impair the right of transferees in good faith for consideration without notice of the existence of the said option. Illustration. A Ramlal, a Hindu who has separated from his father Bishyamlal, sells to C. Ramkumar 3 fields, X, Y and Z, representing that A. Ramlal is authorized to transfer the same of these fields. Z does not belong to A. Ramlal, it having been retained by Bishyamlal on the partition, but on Bishyamlal's dying A. Ramlal as heir obtains Z. C. Ramkumar, not having rescinded the contract of sale, may require A to deliver Z to him.
Here's an elaboration of Section 43 of the Transfer of Property Act, 1882. Key points. Addresses transfers by unauthorized persons who later gain interest in the property. Protects good faith transferees who receive property from someone who initially lacked authority but later acquires it. Conditions. 1. Unauthorized transfer. A person transfers a movable property without actually having the right to do so, either due to fraud or error. 2. Representation of authority. The transferor falsely claims or mistakenly believes they have the authority to transfer the property. 3. Transfer for consideration. The transfer is made for something of value in return, money, another property, or a service. 4. Subsequent acquisition of interest. The transferor later, during the contract's duration, legitimately acquires an interest in the property they previously transferred without authority. Effect of Section 43. The transferee has the option to enforce the transfer against the interest the transferor subsequently acquires, even though the transferor initially lacked authority. This means the transferee can claim ownership of the property to the extent of the interest the transferor now has. Protection of other transferees. The section doesn't affect the rights of other transferees who received the property in good faith, for value, and without knowledge of the initial unauthorized transfer. Example: A sells a plot of land to B, believing they own it, but later discovers they only had a partial interest. A then inherits full ownership of the land. B can now enforce the transfer against A's full ownership, even though A didn't have complete authority at the time of the initial transfer. Important considerations. Good faith and consideration. The transferee must have acted in good faith and paid for the property to benefit from Section 43. Subsistence of contract. The transferor must have acquired the interest in the property during the period when the original transfer contract was still valid. Legal advice. It's crucial to seek legal guidance in such situations to ensure proper understanding of rights and obligations, as property laws can be complex and vary by jurisdiction. I hope this elaboration clarifies Section 43. Please feel free to ask if you have any further questions or require more specific information.